Hi everybody, this is Mark Masters. I'm a senior partner at Seacrest Wardle. I am here today to kick off our every 2 years, Premises Liability webinar series. As always, open and obvious is always the hottest topic, and so we go first. For all of my sci-fi nerd brethren out there, you are going to instantly recognize this. For those of you who are unfamiliar with the Hitchhiker's Guide to the Galaxy by Doug Adams, if you like sci-fi and spoof sci-fi, I highly recommend it. But basically, it's a book about a fictional book called The Hitchhiker's Guide to the Galaxy, which is an explanation of all the things to do and see and dangers to avoid in the galaxy. And on the cover of it, it has in big friendly letters, "Don't panic." That should be what they put on the cover of the Candide Al-Said decision, which was handed down last summer in 2023. There was very much hand-wringing over it. There was very much hand-wringing after it came down. I'm sure you all heard, as we heard from many, I know a guy or a lawyer or whoever that works at this plaintiff office or that plaintiff office, and they have hundreds of premises liability cases they've been sitting on, waiting to file. They're all going to be this avalanche of cases. But as we all know, the avalanche never came. We saw a small uptick in premises cases, and I asked many of our carrier clients the same thing. Have you guys noticed any sort of change? And everyone's like, not really. We saw a couple more, but not a whole lot. They haven't been coming. And I think the reason remains is that the open obvious defense is still a defense. We're going to talk about it, obviously, quite a bit. And also under Candide, a little bit changed, but not a whole lot. And the biggest thing that didn't change are the plaintiffs. This picture is actually of the first house I ever owned. It was in Royal Oak, a long time ago. And so I was single, bored, time on my hands, and I'm like, you know what? The porch is falling apart. This is before I started busting it up with a sledgehammer. The porch is falling apart. I'm going to bust it up. So I busted it up, and of course I'm, doing everything backwards. I break the thing up, and then I order the materials from Home Depot to build a new porch. So I'm waiting for the materials. And at this point, I'm a young lawyer. I'm a young paranoid lawyer. Now I'm an old paranoid lawyer. So what I did is I got that yellow caution tape you see, and I strung it up in front of my house so no one, again, despite that this is a big pile of rubble, I want to, protect myself. I see all sorts of people getting sued for the stupidest things, and so I'm going to put up some yellow caution tape. I come home after work, and yellow caution tape's still there, but if you notice, I'm not sure if you'll see this on what's being recorded, but I'm taking the cursor and circling it around that little flyer that has been rubber banded to my front door handle. That came after I broke up all this concrete and this mess, just like you see it. So some guy handing out pizza flyers decides, you know what? I think it's going to be a good idea if I cross this yellow tape, climb over all of this, it's not even a stable pile, this is a really rickety pile of broken concrete and sharp things and nastiness, and go rubber band this up on the door. This was your plaintiff 30 years ago. This continues to be the plaintiff because history tends to repeat itself. This is my current house. And a couple years ago, now I'm married, and so my wife prefers that we have professionals do things for good reason rather than me doing them. So we were also redoing the front porch. And so this is mid-project of redoing that front porch. And, again, I had a really good contractor. If anybody needs a referral, I'm happy to give them. Give you their names. And they had orange cones. In addition to, again, you can totally see this is something you shouldn't walk through. This is clearly in the middle of a construction site. Put up cones anyway, God bless them. And then you see, right there on the front porch, some Amazon delivery person decided it's going to be a good idea. Ignore cone, 3 cones. All the rubble, all the debris, everything else that's being set up. I mean, these pavers on the edge of the porch were not yet set. This joker decides to go up there and deliver. This is the same plaintiff we have today. And then, again, a couple days later, another delivery driver, same cones, piles of debris. This bozo decides, same thing. Walks through and puts a package on the front porch. Why they just don't put it on a side porch or somewhere else, I don't know. These are your same plaintiffs. And the funny part is, this picture was taken before we had the porch done. I took this picture because I was just so irritated. Again, come home from work. And when there's no problem with the porch, I mean, it's aesthetics. My wife didn't like it, but there's no functional problem with the porch. There's no cracks, broken steps, nothing. The delivery driver decides, well, you know what? I'm just going to throw this box from Costco on the driveway instead of even putting it on the porch at all. So this is when there's no problem with the porch. They dump the box in the driveway, but when the porch is all torn up, cones, etc., they can't help themselves but go through all the debris. So the best defense currently, as always, is these plaintiffs in these cases are often fools. And that was what has made, I think, these cases still very defendable in most cases, still defendable under open obvious in all of these cases would have been. And that's why I think we've not seen the onslaught. So before we dive into Candy a little bit, just to do a little bit of general background, open and obvious, again, just a general negligence case. The plaintiff needs to prove that the defendant owed them a duty, that they breached that duty, which is generally called what the negligence is. You breached your duty, your standard of care owed to your plaintiff, that your breach of that duty, your negligence, so to speak, was the proximate cause of the plaintiff's injury or damages, and that the plaintiff indeed suffered damages. That's pretty much standard Hornbook law. I'm just going to catch up on my little paper sheets here. So now, what happened is the big change with Candeal is that for years under the Lugo decision, which goes back, I think, 2001, what it was, the Supreme Court at that point, 20-some years ago, decided, well, it's part of the duty issue. That's where the analysis took place under Lugo for the last 20-some years, till Candeal came out, which was, dear judges, by edict from the Supreme Court, you judges, you need to take a look at this open and obvious issue. It's a duty question for the court to decide. And what has happened with Candeal is Candeal said, you know what, it's not a duty question. It's really a question of whether or not the duty was breached. And therefore, it might be a factual question for the jury to decide. Maybe it's not. Maybe the parties agree to the facts. They can agree that, yeah, those are pictures of exactly what Mark's porch looked like when I decided to walk through all this and put that package in the middle of it or put that little pizza coupon on his door. So there's no fact question there. But that's basically what had happened. And that's why it's not that much of a panic situation. Because as those of you who have been in the business a while know, even when it was a duty question, how often did you see judges punt and say, this is a fact question. They said they didn't see it. They said there was this issue, that issue, whatever. Or ICE had been present or may have been present or been cold out. Or they're saying there's runoff from a roof. Yada, da, 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 da. All the reasons that a lot of judges would not want to pull the trigger and dismiss a case, even when it was a duty issue analysis, which is typically for the judge to decide. They would then, a lot of times, even under the old rule, punt it to the jury and say, let the jury figure it out. I think it's a fact question. There's a dispute here. So now, again, getting to was that duty which was owed breached? Was there negligence? Under Candeal El Sayad, a possessor need only exercise reasonable care under the circumstances. That hasn't changed. You as a premises possessor just simply need to be reasonable. Under the circumstance, what was reasonable under the circumstances? And as we know, there's so many different factual scenarios. And then we get to the objective test of whether or not this is open and obvious. Right now, that hasn't changed. Again, who knows what's going to happen with our current Supreme Court as far as all these sub-issues go over the next couple of years. But right now, it still remains an objective test under Hofner, another Supreme Court case from 2012. Basically, the question is whether a reasonably careful person, i.e. the plaintiff, upon casual inspection would be expected to discover and avoid the hazard. And a danger is considered open and obvious if, quote, it is reasonable to expect that an average person with ordinary intelligence would have discovered it upon casual inspection, unquote. That seems simple enough, doesn't it? But we know it tends not to be in practicality and in application. So again, as I discussed earlier, Candide basically is pushing that question as much as they can to a jury to decide if there's any sort of question of fact or question of a material fact or material difference of fact that matters to the case. So in reversing the Lugo case, as those of us who have been doing this a bit, remember, Lugo also had a couple of exceptions to the open and obvious defense, which was, okay, if this was open and obvious, well, there's a couple of exceptions to that defense that favor the plaintiff. Meaning, was this open and obvious condition effectively unavoidable? Meaning there's some reason the plaintiff couldn't have avoided it, or did it create an unreasonable, severe risk of harm? And there's a whole body of law and those exceptions, if they're met, what exactly is meant by either of those. But Candile's thrown that out. They're saying, you know what, that's just unworkable. That's out the window. We're not having these exceptions, this issue anymore. Instead, the fact finder, the jury, should consider whether, quote, the possessor should anticipate the harm despite such obviousness, unquote. And again, that's going to be a matter of some dispute for a while. But once the duty is established, and most often there's a duty, and others will talk about duty and classes of invitee versus social guest versus trespasser versus children in general. I'll touch on a couple specific things in my piece today. But it's something typically a duty applies to anyone on the property, even a possessor. There's very little duties owed to an adult trespasser, but there's something you need to be aware of as well. But anyway, under Candile, now the issue becomes whether the condition was open and obvious, and whether, despite its open and obvious nature, the land possessor should have anticipated harm to the invitee, i.e., okay, this pothole, this piece of ice, this crushed grape, this step, whatever it is, okay, fine, we can agree it's open and obvious. Now the question is, does it still, should the possessor anticipate harm to this visitor, whether they're an invitee or a social guest, despite the nature of the open and obvious condition? Then, if that somehow can go to the jury, the next issue is to consider is the plaintiff has comparative fault? Are they at whole or in part responsible for their own injury? Determination of the plaintiff's comparative fault may also require consideration of the open and obvious nature of the hazard and the plaintiff's choice to confront it. That's again Candile Alciad. These are the statutes right here on modified comparative negligence, which have been in effect for almost 30 years now, 1996 when they went into effect. MCLA 600.2959 and 600.2955A. So 600.2959 simply says if the plaintiff is more than 50% at fault, they cannot recover any non-economic damages. That's their pain and suffering. However, if they're not intoxicated, and they are more than 50% at fault, they still get a pro rata share of any economic damages. So let's say you have a surgeon making a ton of money a year, and they get hurt, can't work again, lose their hand or something. And the jury comes back and says, you know what? That surgeon was 75% at fault, but defendant was also 25% at fault. So what that means is the surgeon can't recover any money for the pain and suffering associated with losing her hand, but she can still make a claim for, I can't be a surgeon anymore. I can't do surgery. I only have one hand now. And so you look at her claimed wage loss over the course of the rest of her career, and then what is that wage loss reduced by her 75% comparative negligence, and then you get her damages, which are only economic. And medical bills, same thing. She gets a pro rata share of medicals and any other economic damages she may have. However, if our surgeon is drunk or high or otherwise intoxicated, and that is part and parcel of her comparative negligence, and she's more than 50% at fault, under 600.2955A, she gets nothing. So don't do something wrong and be drunk at the same time. So let's talk about Candile a little bit. Don't be afraid of it. These pictures are actually, these were taken by me actually. This is my case. This is one that I had won previously under Lugo, which was dismissed a couple of years ago. This is a lovely little place. If you're ever in downtown Rochester, Michigan, Rochester, Michigan has a very cute downtown, especially during the holidays. It's all lit up really pretty. They have these snow and ice festival things where these ice sculptures. All the businesses are open late. It's great. So this is dessert Oasis. It's a little coffee shop. They usually have a little open mic where they'll have some person or persons there just strumming a guitar and singing songs. So it's a great place to go hang out after dinner. And my wife and I, my family, we've gone there plenty of times before they were my client. And so what happens is, in this case, plaintiff's coming in. This very nice little lady. You can see her in the second picture from the left. She's seated at that little cafe table next to the man with the glasses standing next to her. And what happened was she was going in. She was with a group of friends, like her adult children and some of their friends and so on. And she's going to walk in and use the bathroom. She wasn't even intending to get a cup of coffee or dessert or anything else. She's still being invitee, so the highest level of duty is owed to her. She's going from the sidewalk. It's nighttime. She has terrible night vision, she says. She's an uncontrolled diabetic for years. That doesn't help vision either, glasses, etc. And a lot of people on the street, as you can see in these pictures, the three pictures on the right were taken by her family friend, or her, I think it was her son's friend that was with him, who's an off-duty police officer. The one on the left was taken by me later on. And so anyway, she trips and falls walking from the sidewalk up onto this raised step where you see this terracotta, this orangish kind of tile. She never looks down, never sees it, etc. Real nice lady, but she simply just wasn't watching where she was going. Nothing's wrong with the step. It's up to code. And that light you see, that street lamp, you see in the picture on the left, that green lamp, which I took that picture during the day. Those of you who are familiar with downtown Rochester recognize, oh yeah, that's up and down Main Street, light after light after light. And the weird thing about these little street lights is that number one, the street lamps are actually in the sidewalk, and the light is curled over from the lamp pole towards the businesses, not towards the street. And this light pole is dead center in front of this step. And as you can see from the third picture from the left, in the upper left-hand corner, you see that street light's on. The place is lit up like a ballpark. That's in addition to the other lights that are inside the vestibule area where she's sitting, because you can see where she's sitting. See the little display cases for the jeweler that's next door? You can see that the spotlights are shining down from the ceiling inside the vestibule. That's what's lighting the tops of those awnings or covers, or whatever you want to call them, to those display cases. Tons of lights. And on the far right, that picture, that again is one of her family friends with her that night, and they're taking a picture to illustrate. They're all thinking lawsuit right away. They call 911, not for assistance, just to get the police out there to document the accident. That's how litigious people are nowadays. So anyway, they photographed their family friend, and a little couple side notes here. So number one, he puts his foot next to the step to show, yeah, there's a step there, no kidding. But look at the shadow that's cast. That is not from the flash. Obviously, you can tell from the angle of the photograph that's not coming from the phone that's recording this. That shadow is being cast by that super bright street light right there. And you can also see, because of the shadow variations, the lights underneath the vestibule are also lighting up this area as well. And so their argument was, oh, well, the face of the concrete step right down here, the vertical face, that's kind of the same color as the concrete sidewalk. It's not quite, obviously, but that somehow camouflaged it. Plenty of cases that say no, a concrete step going to concrete step, that is not camouflage. It does not take something out of the open and obvious realm. And certainly you have the terracotta on top, which is obviously a contrasting color, etc. So we won this, goes up on appeal. It gets stayed in the Court of Appeals pending a decision from the Supreme Court on the Candiel case, which took a couple of years. So this is just sat there, just getting older for a couple of years, waiting for Candiel to come down. And then after Candiel came down, okay, we realized this case is going to be sent back to the trial court, as most cases were. So we got ready. So I got ready, and then lo and behold, they sent it back down to the trial court for a further determination of this case on our motion based on Candiel. So I was ready. So as soon as this thing got back to circuit court, I filed my motion for summary disposition based on the new Candiel case. And here's something to be aware of as well. Oh, a couple things, I promise. As far as the photographs go, it's always important for every single case to get the plaintiff's photos. So these 3 photos on the right, they took night of accident. She's still there. She's sitting in that chair. She had some broken bones, bruising. She had, her face didn't look good because she had black eye and stuff. She just went down. And she was a real nice little lady. And so I get electronic copies of all those photos with the metadata intact. And so many times it's like pulling teeth, but you need the metadata, because that metadata, for those of you who don't know what that is every time you take a picture with your phone or any electronic device, as a user, you don't even see all the data that's embedded into that photograph. And with phones, it includes things like GPS, time of day, and more importantly for your cases at night, was the flash on when these photos were taken? Because I get to her depth, Mrs. Roman is her name. Mrs. Roman, these photographs, to show the area of the accident, accurately show them. You guys took them, your party took them. This is you in the picture. This is your son's friend in the picture, et cetera, et cetera. This light was on, that light was on. Yes. You took it all that night. Without even, yes. Okay, ma'am, it was super lit up, just like a ballpark. Well, the flash of the camera, no, ma'am, flash was not on. Because here are the photos. It says very clearly in the metadata, the flash was not turned on. This is just plain old photos that your friends took with a camera phone. No flash, no augmentation, no changes at all to anything. This is just how it looked. Yes. So, okay, that's on metadata. So now, note on the legal aspect of these cases that are coming back from the Court of Appeals, they're often coming back from the Court of Appeals as simply saying, we are sending this back down for reconsideration in light of whether or not this thing should be dismissed under Candide LSAD. Well, in the Vroman case, what was very interesting is, the trial court said it was open and obvious. And the Court of Appeals, we actually won in the Court of Appeals before it got stayed. We won in the Court of Appeals and said, yes, this is open and obvious. No case. And then the Supreme Court put a stay on it because they filed for application for leave to the Supreme Court. It gets stayed there. So now I've got these two decisions from the trial court and the Court of Appeals saying this is an open and obvious condition. And now the decision comes back down. This needs to go back down to the trial court for consideration under Candile rather than under Lugo, i.e. duty versus breach of duty. Now, what's interesting here is no one reversed the trial court's finding that it was open and obvious. No one reversed the Court of Appeals finding that it was an open and obvious condition. That test whether or not it's open and obvious hasn't changed. So one section of my motion was, hey, look, this is something called the law of the case doctrine. There's actually law on this. So what happens is it went up on appeal, but it came down on some discrete issues. So the other conclusions by the Court of Appeals, i.e. that this was an open and obvious condition, that ruling by the Court of Appeals and by the trial court was never overturned, was never touched. It was remanded for consideration on a different issue. So therefore, dear trial court, in round 2, you've already decided this. The Court of Appeals affirmed that it was open and obvious. Therefore, we're not relitigating whether or not this is open and obvious. That's done. The law of the case doctrine says you cannot relitigate this, as well as subsequent panels of the Court of Appeals cannot relitigate whether or not this condition was open and obvious. Trial court agreed with me on round 2. Trial court also did a really nicely written decision. If anybody wants to let me know, I'll send it to you, from Judge Grant in Oakland County, that says, no, even under Candile, this is what Candile says, it's still open and obvious. And still under Candile, if there's no factual question, the judge can make a determination whether or not to throw the case out. So she said, it's open and obvious, I'm throwing the case out. Boom, done. And now we're going up on appeal round 2. And I think we're going to win. This photo is from another case I had, which was decided for the first time after Candide LSAD came down. I know the plaintiff's attorney on this case really well, and I filed a motion for summary after because of the timing of it. But this is an area inside my client's car dealership service area. And as in most car dealership service areas, they're really well maintained. There's nothing wrong with this step. It meets, just like the step at Desert Oasis, it meets every code, standard, nothing. So, and actually, the plaintiff's expert in both cases, different plaintiff's attorneys, same expert in both cases. Stephen Ziemba, who you always see in these kinds of cases, comes up with these ridiculous reports, and frankly, there's plenty of decisions in the courts of appeals that are not kind to his opinions in other cases, which I always make sure I reference in my motions and my pleadings when he comes up in a case. because he just says this random stuff. He'll say, oh, there's a duty. He's some quote-unquote safety expert. And so in regard to this dealership, there's nothing wrong with this step. Lady comes in, brings her car in for some service. She talks to the service guy at the desk. She gets up. She then walks off the upper area, walkway, and down into the street level, if you will, where her car was parked, and then falls because she just misses the step. And it was painted yellow on the top too. It's not just the face of it, but there's like about 1 or 2 inch strip along the top of this whole step that's painted yellow. There's not a crack in it. It's not broken. It's not slippery. There's no water, ice, foreign materials, oil, nothing. It's a concrete step. This is like every sidewalk you've ever seen in your life. And she just wasn't paying attention where she was going. And this was pending up in front of Judge Christensen in Genesee County. Again, really good judge, extremely well prepared for the motion. But I filed this motion, and the plaintiff's attorney calls me. He's like, "Oh, Mark, you might not know this, but this Candid LCN case came down." I laugh. I'm like, "Yeah, I'm aware. Note that it's cited repeatedly in my motion, Todd, because I still win." And I'm like, "All right, I'll just look forward to seeing your brief." And to his brief, he attaches a letter from Mr. Ziemba. He's not even a doctor, PhD, nothing. He's just, not even an engineer. He's a Mr. Saying, "Oh, you should have had some sign up about this step." And I'm like, "Are you kidding me?" And so, and he has a picture that he cut and pasted off of the internet of like a picture of a figure like falling off a step. And that's what they're saying. And so we get to the hearing. And it's always important. I always think it's important to go to a hearing like this in person, and I did. I drove to Flint because I wanted to get up to the court because I wanted to tell the court, I'm like, "Your Honor, this is ridiculous." Because number one, this sign, first of all, he doesn't attach an affidavit as required by the court rules. He just gives this unsworn letter. So let's assume this letter is right, but it violates the court rules. You shouldn't consider it. But even if you're going to consider it, let's look at what's written in it. How often does this sign, for instance, where does it come from that this sign is required other than the world according to Mr. Ziemba? There's no statute noted violated, and actually there's nothing I could find that was violated. Code, standard, ordinance, anything. Where is this coming from that this sign is somehow required other than in the head of Mr. Ziemba? Number one. Number two, where's all the studies that show this sign would in any way have made a difference in this case or in any case? What language is it supposed to be in, or language is it supposed to be in? What color is it supposed to be? Is it supposed to be on the ground or on the opposing wall that's like 30, 40, 50 feet away? Or if it's supposed to be on the ground, how often is it supposed to be on the ground? Like every 5 feet, 10 feet, 2 feet, 6 inches? Colors it should be, how big, dimensions it should be, etc. Should we have to drill poles every 6 inches around this curb with a sign hanging from it of whatever stated size, color, language, etc., height of the sign? This is just nonsense. And I said, from my own perspective, okay, when you walk in my house from, the living room to the dining room, they're different levels, same wood floor, but it's different levels a step down. Am I supposed to have it painted now with a sign? And how am I supposed to know that's supposed to be the case? Is that true of all, 8 million of us homeowners in the state, or how many people live in the state? Are we all supposed to call Mr. Ziemba to see what he's thinking? And then what about every other plaintiff expert that comes out of the woodwork? I mean, there's a lot of these guys out there, right? They'll just say whatever. What if they disagree? Who am I supposed to go with? And then the reason I go up to the courthouse ahead of time, look around is, well, Your Honor, because I look in here right now at your very own courtroom, it's carpeted, and I see there's a step up to the witness stand. There's no sign there, same carpet. And he's just saying, it should somehow be more noticeable somehow. And there's no sign there. When I walked in the steps of the courthouse, I parked across the street. I walked from the curb to the sidewalk. No sign there. There's no sign when I walked up to the steps of the courthouse. There's no signs on the steps as I walked inside the courthouse, and there's level changes. This is just patently ridiculous. Just absolutely ridiculous. And the court agreed. And now that's being appealed, and I expect to win that as well. So, other ways plaintiffs try to get around our open and obvious defense. And a lot of these cases are all still good law for now. What if this is a physically disabled plaintiff? The classic example, if the plaintiff is blind, that doesn't matter, still an objective standard. Would a reasonably prudent person have seen this on casual observation and avoided it? And the case law is clear that a quote-unquote, your average reasonable person is one of normal bodily health, i.e. sighted. So you can't, premise that, a premises possessor does not need to make their premises safe for blind people and people with other sorts of physical handicaps other than those required by the ADA. And that's a whole, you need to be ADA compliant, obviously. But blind, if it's open and obvious to a sighted person, it's open and obvious to a blind person under the prevailing law. Similarly, what about persons with diminished mental capacity due to alcohol, i.e. they're drunk? No, sorry. Because you're drunk, that's your problem, that's not the possessor's problem. I don't have to make my premises safe for drunken people. Next, what if the person has diminished mental capacity due to age? Well, there's one case at least for minors. Yeah, if they're a minor, you got to take that into account. And in this case of Bragan, that involved a kid using what's called a Jacob's ladder at a little, I think this was at a little orchard, like apple orchard kind of situation, but you'll see these at carnivals and fairs too. Basically, it's a rope ladder that is tied higher on the top, and on the bottom it's usually anchored to the ground, and the top is usually like 6-8 feet up. And it's a rope ladder, but that top and bottom tether points come down to a single rope. So the left side of the ladder and the right side of the rope ladder are tied together to a single point, so it flips. So you try to climb this thing up without flipping off of it, and you ring a bell or something and you get a prize. And normally when you go to a carnival or fair or something, they'll have some inflatable, like a moonwalk, inflatable balloony kind of thing underneath it. So if you fall, you just bounce on that big moonwalky thing. But this farm apparently just had some hay down, and so not enough hay, and the kid broke his arm. So that was then considered to be a jury question for them to consider if a child of like age and experience, that's a standard for kids, would have appreciated the open and obvious condition. Now, from a file handling point and a claims handling, for those of you who take recorded statements, God bless you, before they get to a litigated stage when you can, you walk that kid through it. Because every day that kid gets older, and that kid, when you ask him that question, like, okay, the accident happened and he was, 10, and now he's 13 or 16, he doesn't remember that he didn't know certain things or did stupid things when he was 10 that he doesn't do when he's 16. Certainly does stupid things at 16. That doesn't change, but the kinds of stupid things change. But you ask him questions like, well, you knew that this was dangerous. You knew this ladder could flip. You knew that there was, a certain amount of hay on the ground that if you fell, you could have broke your arm. And that's true even if you're doing it at the carnival. Yeah, you said maybe you've done this before at carnivals or since. Certainly you want to get to the before part. But before this, you've done this kind of thing at carnivals. They have a little inflatable moonwalky thing. But even from that if you fall on that, you can still break your arm just like you did here on the moonwalky thing. You have other friends, experiences, etc. Again, I've got 3 kids myself. They're all a little bit older now. But they're 14 through 19. And I've seen all their friends I've seen get really badly injured on all sorts of trampolines and moonwalks and everything else. So typically these plaintiff kids in these cases will admit to all that. Yeah, you knew beforehand, any of your buddies ever have an accident like this where they went to a carnival or went to something, used a Jacob's ladder, got hurt, this, that, other thing, yeah, or maybe they did, maybe they didn't. But you knew beforehand of the danger. You knew beforehand, before getting on this Jacob's ladder, of this danger. You knew if climbing this thing, the whole process of this, you've seen people on it, you've seen people fall before you got on it that day. You could flip over, fall down, and even if no one's ever used a Jacob's ladder, even if you've never seen it, you certainly knew that falling from that kind of height, you could hurt yourself, because your mom's always yelling at you, get off of that thing, don't climb up on there, you can fall and hurt yourself, you're going to break a leg, don't come running to me, etc. You were told all these things by your folks ahead of time. You knew all these things before that day. You knew that when you got on the Jacob's ladder. Therefore, you take away that fact question. So when you get to the motion, Your Honor, this kid, little Joey here, he already testified under oath at his deposition, and he was 12, 13, 14, whatever he was, so he was old enough to take the oath. He swore under penalty of perjury that before he got on this thing, he knew it could flip. If he fell from that height, he could hurt himself. He could hurt himself just like the way he did in this case. He knew all these things beforehand. He did it anyway. He was the only moving part on the Jacob's ladder, etc. He saw people do it successfully. He saw people who fell off of it and didn't get hurt. He made the choice, etc. He could have avoided the danger. So it's open and obvious. And so he can't get around it by saying, despite its open and obvious condition, that it removed the danger or not, because he could have simply not done the thing. And if he's charged for it, yeah, he could have saved his $1 or $2 or $3, whatever it is, and not even played that game because, you know what, I don't want to get hurt. Next one. There's a couple of open questions on other kinds of mental incapacity, because there's a mental incapacity on, that quote unquote incapacity under law because of your age. You have the Jacob's Ladder situation. But there's other cases that haven't been addressed. People with some sort of mental disability, people, maybe people with dementia or Alzheimer's. That's an open issue. And the problem with them versus children, because as children get older, by the time that the accident happens, case gets filed, jury sees them one day, for a kid has until age 19 to file that lawsuit. Up to the age of disability, i.e. 18 is removed plus 1 year, so that's 19 for the kid. That kid's getting older, smarter, and subconsciously for the jury, more mature, because they're looking at this 19-year-old in the witness stand, or sitting at counsel table in this lawsuit, rather than the 12-year-old kid who broke his arm. Like, yeah, I understand you're 12 and a half, but I'm looking at you, kid. You got a full beard at 19. This is your problem. Get over it. If it's someone like that has dementia or Alzheimer's, their problem is going to get progressively worse. So by the time they get to a jury, they're going to be much worse than they were at the time of the incident. So that's going to be a problem for you as a defendant or defending these kinds of cases. So let's talk about one other important distinction. The open and obvious defense applies to possessors of land, not owners. An owner may be a possessor, and a possessor may be an owner, but they're not synonymous. So one who has possession and control of the land is the one who's subject to premises liability, number one, and enjoys the open and obvious defense. That's it. So if you are not a possessor of land, then there's a couple class of examples, like snowplow, subcontractors might be on the job site. That's the next slide. Like in the Kafari case, there was a plumbing subcontractor on a job site, plant tripped and fell over a bunch of stacked pipes. They asserted the open and obvious defense, and the Supreme Court was like, no. You subcontracting plumber did not have possession and control of property. The general contractor had possession and control. The owner maybe did too. They could have had co-possession. But certainly you, as the plumbing subcontractor, did not have possession and control of this property. You left a bunch of pipe on the ground, so you don't get the open and obvious defense. You'll have comparative negligence as a defense, for sure. And you can argue that to the jury, but you're not getting out an open and obvious. Similarly, you might have, in the commercial tenant area, you might have a commercial tenant like, I don't know, like some, ABC, Joe's Pizza Company is leasing out from, Dave the landlord. So Joe's Pizza Company has possession and control of that parcel, and the landlord probably has no possession and control of that property. If in the lease there's some sort of right for the landlord to re-enter the property, like to show it to potential future tenants or a buyer or whatever, make repairs, that's not good enough. That doesn't give the landlord possession and control of that commercial property. If it's a residential lease setting, different rules apply. That'll be discussed at a different installment of our little seminar series for the special consideration for residential landlords. So any non-owner, non-possessor, another good example is snow removal contractors. You hire, the possessor of land hires XYZ snow removal contracting to plow the parking lot in the winter. That snow removal contractor does not enjoy the open and obvious defense. They have other defenses, which we talked about in other installments, but they don't have the open and obvious defense because they were not in possession and control of the property. So they'll have general, but similarly, you can't make a premises liability case against non-possessors either. So does that benefit? You can make a general negligence claim against them, and there's defenses available for them in that regard, including lack of a duty under Foltz and so on that other people will talk about in more detail. Other common plaintiff strategies to avoid the open and obvious defense. Remember, it's an objective standard. Plaintiffs will often argue it was invisible. Invisible ice, black ice is always fun. And they run into a difficult problem. It's a hard needle for them to thread, whereas I fell on this invisible hazard for whatever reason, but yet you, the premises possessor, should have known it. And so typically those kinds of claims involve black ice or quote-unquote invisible ice. My line of questioning that I always like to go through in those cases. Okay, ma'am, how tall are you? All right, you're 5'8". And then you were obviously, you lived in Michigan your whole life. You're aware of snow and ice conditions. It's cold out. You're aware of melting or freezing, et cetera, et cetera, et cetera. And you're in a parking lot, sidewalk, et cetera. And was there a recurring problem here where there was always a puddle forming? No, yes or no. But the fact of the matter is, you're saying that you were taking appropriate care for your own safety. You were watching where you were walking because you lived in Michigan your whole life. You know that, number one, ice could be under snow, or there could be black ice. So you're always very careful walking in the winter. You got the right kinds of boots on. You're watching where you're walking. And you're taking extra care for yourself, weren't you? Because you didn't want to fall and hurt yourself. No, always agree, yes. Yes, so in taking extra care for your own safety, and you're watching every spot where you're going to place your foot from your 5'8" height, standing there, you could not see any ice. Correct. Invisible. And so after you fell, now you're laying on the ground. Could you, once you're laying on the ground, see the ice? Sometimes they say no. And then I'm like, well, how do you know it was ice? I could feel it. Okay, so other than feeling it with your bare hand on the ground, was there any way anyone could have seen that this ice was present? No. Other than feeling it with your bare hand on the ground, is there any way that anyone would have been able to know that this ice was present? No. Great. I'm not going to win an open and obvious motion because of the question of fact. I'm going to win my lack of notice motion, which you'll have her discuss later, because again, how am I, as a possessor of land, supposed to find this invisible patch of ice of an unknown size that's been there for an unknown amount of time with no recognizable potential source for this invisible ice other than by crawling around my property on my hands and knees with my bare hands feeling to see if there's ice? Obviously, that is not a duty anywhere imposed because none of you have done that ever. You're never going to meet anyone in your life who's ever done it because it's absolutely ridiculous and you have no such duty. So getting back to this slide. Other ways plaintiffs try to get around it. If the plaintiff didn't see it, they're going to try to get, did other witnesses see it? Did other people trip or slip on it? Sometimes you'll see people who I usually just shake my head because I think they're lying. Oh, there was some unnamed employee of the store, whoever came up and said, oh, I knew I had to clean that up, or I knew I had to do something about that, or someone said something at the scene and said, oh, Mike, you're supposed to clean that up, or some other customer said, I just told the manager about that and they didn't do it. I told the manager 10 minutes ago, they didn't do anything. You're going to see a lot of that. And then, okay, what did this person look like? What was their name? I don't know. They were wearing a blue shirt like everyone else wears at the store, and that's how I knew they worked there. Again, you'll see people, frankly, I just think make it up. And then why the issue then, if they're saying they didn't see it, are there other reasons other than invisibility they didn't see it? Was it somehow concealed? Were they in a car? If it's in a parking lot, were they in a car that they drove to this parking lot? Did they drive over it, headlights on, see it? Was it dark out? We'll get to darkness in a second. So on. So next slide is, I didn't see it because I was distracted. And so the Lugo case, plaintiff said, Mrs. Lugo said she was walking in the parking lot, and she said, I didn't see that pothole because I was busy looking at traffic instead of where I'm walking to avoid getting hit. That's not good enough. That's not a distraction. In the Maurer versus Oakland County Parks case going back, to 1995 or so, another Supreme Court case, there was two cases that were consolidated. In the Maurer case, it was the Panion Chevrolet, I think it was the defendant in the companion case, Kathy Maurer's case. And in that case, at the car dealership, there was a, quote, bizarre arrangement of steps and doors, unquote. So because it was this unusual situation, the court felt that was good enough to avoid application of open and obvious defense because it was this bizarre arrangement of steps and doors rather than something you normally see everywhere. And I didn't see what the dealership area looked like, but apparently it was a bizarre arrangement. So something to be, is this normal? Like I just showed you my other car dealership case, you just saw that photo of a few slides ago. There's nothing bizarre about that arrangement. It's a plain old step, just like any sidewalk corner you'd see in your life. Other one, my favorite is what the plaintiffs will try to call the storekeeper's exception. They try to create this third exception or Lugo, meaning, oh, you're a retail establishment. You had this really big display of Twinkies or something with all these big signs and sometimes flashing lights or little, streamers or whatever, trying to draw my attention away from the floor and instead onto the shelf, onto the display of these items you're trying to sell me. So therefore, the open and obvious doesn't apply to me. And the courts have been clear. No, sorry, your claim that the store possessor somehow distract you with their shiny displays is not good enough to get around the open and obvious offense. It's not good enough to get around everyone's duty to take appropriate care for their own safety and watch where they're going. We've all fallen, right? I've certainly fallen plenty of times in my life. Sometimes I trip over something. I just did it actually in a retail store the other day. I was cutting through the aisles and I didn't fall. I tripped and stumbled and I tripped over a yellow caution sign. And we've seen those cases too, right? Someone trips and falls on the caution sign. And I just did it myself. And you know what? It was all my fault. I wasn't watching where I was walking. Similarly, I slipped and fall. I've fallen on ice. I missed steps. We all have. Horses and people. We're the only animals that trip over our own feet. So anyway, the invisible thing. We talked about the invisibility issue on the slide. There's a notice problem for plaintiff who's invisible. Again, special issues for children. In this case, there was a chain that someone had strung across a parking lot so people didn't go into the parking lot who didn't belong there. Some 12-year-old kid was riding his bike, rode right into the chain, got hurt. They had an expert that said, oh, you wouldn't see it. It's a conspicuity issue. And so that was from 2001, Pippin, and they decided to send that one to the jury. So again, kids are often, if not always, a special circumstance. Other issues like, it's hard to see what was on the floor. You got water on the floor in a store that maybe has light colored tiles. Hard to see. It's transparent. They try to then dodge a bullet on the notice issue because maybe there's a rug present. That's why you have a rug there, because it's a recurring condition. It was raining outside. It's been raining outside a while. People are trekking in water. The weather records show it's been raining for 2 hours. You guys should have done something about it. It's got to be a mixed bag whether or not the judge is going to say that's open and obvious or if it's a jury question. Ice hidden under snow is open and obvious. Again, we all lived in Michigan, or most of us, or many of us have lived in Michigan. For the plaintiffs here, oftentimes we lived in Michigan for many winters. And they'll admit, yeah, I'm aware ice forms under snow. I'm aware that there's often no way you can tell if there's ice under that snow, but there often is, and I'm aware of that just from the general wintry conditions. It's just the indicia of ice and snow melting and freezing during the winter. It's a common occurrence and to be expected. Again, this is Michigan. Deal with it. Another consideration, too, is when you have ice and snow cases. I always like to go get photographs of the courthouse during winter conditions. Especially some counties have terrible parking lots that are just riddled with all sorts of clumps of ice and everything, even though the county plows it themselves. I always love attaching those. Or the steps are broken up and I got a broken step case in the courthouse. Your Honor, this is exactly what it looks like out front. So are you going to shut down the building? No, you guys haven't done it yet. Is the county unreasonable? Is the state unreasonable? It's helpful, I think. It's also a good argument to the jury. Ladies and gentlemen, when you came in here 3 days ago and you've been coming here every day since, you've crossed those broken steps, right? None of you fell. So black ice we talked about, look at the circumstantial evidence, those wintry conditions, melting or freezing, could help you. Specific weather conditions at present at the time of their fall are important. And again, wintry conditions, this is no news to anyone who's handled Michigan cases or lived in Michigan. It's wintertime. Watch where you're going. Darkness is always my favorite. Cases have gone both ways, but really there's a prevailing case of Singerman, which is a Supreme Court case. And the cases that go the other way, it says, well, darkness, darkness concealed the issue, problem, etc. Typically, Singerman never seems to be cited by the parties, and so I blame the defendants for not bringing up the Singerman case in those cases, because Singerman, again, is almost 30 years old. Darkness in and of itself is an open and obvious condition. If I'm blindfolding myself, or I turn all the lights off and walk across an otherwise perfectly fine area, yeah, that darkness is an open and obvious condition, or sometimes it's at nighttime. And one time I had a case where I represented an apartment complex. It was a large complex. It was a hilly complex, and it was Halloween night. And plaintiff didn't even live at the complex. She just brought her kids to the complex because all the apartments, it was a nice neighborhood. good candy, and high density as far as homes and doors. So you can cross a lot of houses, a lot of doors in a short distance. And so she's unfamiliar with the area, so she decides, I think this was in front of Judge Crane as well years ago. She decides what's going to be a good idea is that, she's going to cut through all these bushes and landscaped area. And I don't know where the heck she thought she was going. And she walks off like a 6 or 8 foot high retaining wall that no one should ever be near as a pedestrian, because again, she had to go through all this landscape. There's no path. She's cutting through all these bushes and shrubs and everything else in the dark, and she walks right out of this thing and she shatters her leg. And again, there is no requirement that I light up every inch of my property like a ballpark. There's no requirement for any of us to do that. It's just ridiculous. What's lit up were the sidewalk areas and the parking lots. They weren't lighting up the woods that this lady basically fell into. But anyway, getting back to the Singerman case, this was a hockey arena where the plaintiff, an adult, experienced hockey player, gets hit in the face with a puck. And again, I didn't see it because it was so dark. The darkness, the lighting conditions are open and obvious. You know what you're getting into. It's a hockey game. You've been playing it all your life. Pucks go flying. This is your own fault. This is nothing wrong with the premises. Just because it's dark doesn't somehow get you a free, spin at the wheel with the jury. And ultimately, too, that's what I'm trying to say as far as don't panic. We haven't seen this onslaught of cases because ultimately, these are not good cases. If the plaintiffs, oftentimes these are not good. Sometimes they have very good premises cases, don't get me wrong. But a lot of times, these are not good cases for the plaintiffs because, again, they have to go in front of a jury and explain, hey, look, because the plaintiffs are always in their position. I didn't do anything wrong. You didn't do anything wrong. You just cut through this landscaped area. There's all these you had to hop over bushes, lady, at a place you don't live. You were not invited to. You're just coming there basically to get candy from all these people who live there. They have no sympathy for you. Because, what are you doing? You're walking through this landscape area, and that's what you want to do. You want to spend all that money getting to a jury. You, the plaintiff, all these costs, experts, etc. You have Ziemba come in here and say there's something wrong with the bushes. We should have, glowing bushes? Or whatever. So, again, they're not really anxious to go to a jury on a lot of these cases. Next slide. So another way to try to get around it, I didn't see it, and my expert agrees. We talked about Mr. Ziemba and these two cases that I had that you just saw the examples of Desert Oasis, and the other one was the car dealership. Comes as forth with, it should have been safer. You should have had this sign up. Based on what? You? Just making up stuff, making up duties? You don't get to do that. You don't get to tell a jury that we have a duty. Is there a law about this? Is there a standard? Is there an ordinance? No, there are standards and ordinances regarding steps and what they need to look like. And yes, these steps were perfectly fine under all applicable ordinances and standards. And in the case of the dealership, they even went so far as to paint a yellow line on it, which isn't required by anybody. And your lady still walked off it because she just wasn't paying attention. She didn't care. So therefore, ladies and gentlemen of the jury, why should you care more than her? It's her leg, right? Another good question I always ask people is, ma'am, knowing what you know now, would you watch where you're walking? And that's after a big lead into this damages is so horrible for you. Oh, it's so terrible. And your life's so impacted and awful, 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 awful. And you have surgery and a broken bone and cast and people are ridiculing you about it, And you're embarrassed by your scars from this and so on. So if you had to do it all over, what would you have done differently? Watched where you were walking? Because if you watched where you're walking, none of us would be here now. You just got in your car and been happy and got your oil changed, whatever it was, and driven away fine. So again, with these experts, the opinions are something that you often don't even have to depose them a lot of times because their opinions are such garbage. And the plaintiffs just tend to rely on those. But again, I usually recommend deposing experts. Mr. Ziemba, you don't need to do it so much. But definitely if he comes up with something novel, get him in there and just again, same thing. Where's the standard coming from? How is anyone supposed to know they're supposed to do this other than calling you? And you're some sort of safety expert. These are your, quote unquote qualifications. But there's other guys like you with the same qualifications. And you guys don't all agree on a standard. Because we can call these guys, they're going to have some other different kind of whatever they're going to say. How do I follow all of your rules? I don't have to, because that's not the law. That's not my duty. So, and if there's a building code violation, don't get too hung up on it, because a building code violation does not create a duty to the defendant. It might be evidence of negligence, but again, okay, fine. If there's evidence of negligence, but I still have the open and obvious defense, I still have modified comparative negligence. So my open and obvious motions right now, in addition to open and obvious, also have a subsection of, well, if Your Honor thinks it's an issue for the jury in regards to open and obvious, we can all agree on plaintiff was comparatively negligent. And then we can all agree on that plaintiff was more than half at fault for this accident. You take a shot at it, because you'll find cases and they'll get upheld depending on the case. They get dismissed because of a plaintiff being more than 50% at fault, at least on the non-economic claim, and that changes the dynamics of a case greatly. That's everything. If you have any questions, please feel free to call. Please feel free to email me. If you want to know more about any of the cases of mine that I talked about, I'm waiting for decisions about those from the Court of Appeals in those two cases. It's going to be, I'm sure, 6 months in those. I have a third case that came back from the Court of Appeals we're waiting for a decision from, also from Judge Grant, so I am optimistic on the right decision being made. But anything you want to know, always feel free to reach out. Always feel free to call. If you don't currently receive our email legal update newsletters, or maybe you got this invitation for this webinar forwarded you by a coworker or a friend or a client or an insurance company, whoever, and want to be on our distribution lists, let me know. And we'll make sure that you can get on those in the future. And thank you very much. I hope you enjoy all of these upcoming installments on the different chapters of the handbook. And lastly, if you didn't receive the handbook, you can get an e-copy or a hard copy, and we'll be happy to send you one. Typically, everyone wants e-copies nowadays, which is actually easier for us, but you can email me about that as well. Thank you very much, and have a good rest of your day.